The Supreme Law of Uganda presumes that a person charged with a criminal offence is innocent until proven guilty under Article 28, Clause 3A. Article 23, Clause 6 further states that any person arrested in respect for a criminal offence is entitled to apply for bail. The law does not classify the cases which are or not entitled to consideration for bail.
The court will analyze the circumstances of each case differently, and either that court may grant the bail or may not grant the bail.
The judiciary spokesperson Jamson Karemani explains why it is important for the accused to convince court why a bail application is being sought for.
He is only allowed to attend to his case while coming from outside. The other consideration court considers is the biggest one. If we release this person on bail, is he coming back to attend his trial?
The application for release on bail requires guarantee that the accused will appear in court as and when needed. This is why the accused is tasked to pay cash or non-cash bail.
That money they are asking you to deposit, it is security. They are looking at, in case you don't come back, is there fallback? Or when you don't come back, there is nothing, the matter ends there.
The cash is deposited to the bank, and when the accused is either found guilty or acquitted, his or her money is refunded. But when the terms given by court are breached by the accused, the money is then forfeited to the state.
Government takes it as revenue because they have also invested in looking for you.
But for non-cash bail, it is upon sureties to ensure the accused does not disappear.
That you have executed the bond of so much, not cash. Now that one remains hanging on their neck. If the person you stood for runs away and you can't trace him yourself, they will come to you and say, you said if he does not come back, you will pay 100 million. Where is it? So the sureties have got to understand that standing for someone is not just a joke. It's not a game. It is something serious. You must monitor him.
When a bail application is rejected by court, the accused is remanded to prison, but for a period not exceeding 180 days for capital offences, while misdemeanors not beyond 60 days.
Much as they may be still going on investigating, that one is easy. You may even be granted bail without a surety. You may not be asked to pay anything. Court will just grant you bail after 180 days.
The judiciary has over time settled scenarios where people are arrested and detained beyond 48 hours, contrary to Section 25 of the Police Act. This calls for a legal alternative where in high-end profile cases, the 48 hours are not enough to carry out investigations to adduce evidence to the courts of law. Ivan Kaahwa, UBC News in Kampala.